So tonight we would like to discuss, as part of our health law and human rights model, we'll discuss the topic, health and humanitarian emergencies. So where we have emergencies, humanitarian emergencies, public health emergencies, what happens to health? What happens to the right to health? I propose that you read some of these core reading materials. We've come across some of them already. So look at Article 12 of the National Community Constitution and Community and Cultural Rights. And then look at the UN Committee report, General Command number 14. And then look at Article 14 of the ICCPR. And then look at the Saracusa principles on the limitation and derogation provisions in the ICCPR. That is, when is it permissible for you to suspend your human rights obligations? So look at the issues of legality, necessity, proportionality. So if you look at the Saracusa principles, they have been provided there. So do well to look at them. These are not plenty. And again, there's an article by Roberts and others. They attempted to look at the mortality before and after the 2003 invasion of Iraq, published in the Lancet. So try and look at that. And then, Medicine Sans Frontières, they also did important work, Murky Waters, why the cholera epidemic in Luanda was a disaster waiting to happen. Now again, I would like you to look at the convention relating to the status of refugees, particularly Articles 20, 23, and 33. And then look at this important academic paper by Hodge and Anderson with respect to legal triage, trying to leverage the concept of triage from clinical settings of medicine to explore public health emergencies. So I'd like you to look at that. You can just download it from the Social Science Research Network. And also look at the Palmer and Martin's article, Public Health Emergencies and Human Rights, published in the European Human Rights Law Review. You also encourage to look at the work by the International Commission of Jurists and the Global Health Law Consortium on Principles and Guidelines on Human Rights in Public Health Emergencies, published in 2023. And with respect to our own Ghana, look at the Constitution, particularly Articles 12, 21, 31, and 32, relating to emergency powers. And also look at the Imposition of Restoration Act, which has been declared unconstitutional in respect by the Supreme Court decision in Professor Kojo Apiagyei Etua and others against Attorney General. You can also download that freely online or from the Danish law. So these are matters I would like you to read to supplement the discussion that we are going to do. So in this lecture, health and humanitarian emergencies, we aim to enable you to develop a coherent conceptual understanding of health and humanitarian emergencies as a multidimensional legal crisis rather than episodic factual events. That is to say that if you have humanitarian emergencies, there are various aspects in terms of the legal challenges or problems that they present. And also to enable you to understand the normative architecture governing health and humanitarian emergencies, including the interaction between international human rights law international humanitarian law, refugee law, and also domestic constitutional emergency regime, just like our own Article 32, as it were. The discussion also seeks to enable you to analyze the legal content of the right to health under emergency conditions, with particular emphasis on continuity of obligations, core minimum duties, and the prohibitions of unjustified retrogression. When I asked you to tell me about the situation on the globe with respect to humanitarian situation, apart from Iran, David also told us about the situation in Gaza and how struggles are being made to even to get food and essential medicines to people who are in desperate need of same. We also seek to enable you to be in a position to examine the legal significance of vulnerability in emergencies, particularly vulnerable groups like children, refugees, displaced persons, women, and persons with disabilities, and the heightened duties owed to such groups under international law. So these are some of the things that when you read the material and then we do the discussion, you should be able to, and again, we should also be able to evaluate the application of international humanitarian law to health protection in armed conflicts, including obligations relating to medical personnel, facilities, and indirect health harms. Again, we will be able to draw a distinction clearly between limitations and derogations of human rights in emergency contexts and understand the legal conditions governing each under international and constitutional law. Another interesting objective we hope to achieve is to be able to introduce and apply the concept of legal triage as an explanatory framework for understanding how law prioritizes and disciplines actions under conditions of scarcity and urgency. So if you remember, in medical setting, you have accidents, you have large-scale situation, people, patients all over, and then overstretched resources and personnel. How do you make a determination as to who should be treated and so on? So the concept of triage enables some prioritization to be done. So we would draw upon that concept to see how law also prioritizes and sort of disciplines actions under conditions of scarcity and urgency. Again, we also hope to be able to assess the legality of emergency governance in Ghana, where a state of emergency is declared. What are the legal parameters? And the COVID-19 response will be used as a reference point. And as we have already mentioned, the case of Professor Kojo Apiaje against Attorney General, which sought to challenge the response of the state, particularly with respect to the constitutionality of the Imposition of Restorations Act. So these are some of the matters that we will be exploring. Good. So to start with, we need to note that health and humanitarian emergencies occupy a distinctive and demanding space in legal analysis That is to say that when you have humanitarian emergencies, it presents its own unique challenges with respect to health, access to health, and what the Lord say. Because such emergencies are moments in which human vulnerability is most exposed. State power is most expansive, and law is most severely tested. It's not too long when all of us witnessed even the pandemic, COVID-19, where human beings were actually stripped bare of how miserable and vulnerable we are in the face of existential threats like the pandemic. And of course, how the state also, in attempt to contain the situation, was behaving like the octopus, so to speak, grabbing power here and there and trying to do whatever it can to stamp its authority and contain the situation, including restricting movement and so on. So in all this theater, you see that law is being tested in very significant ways. So we have talked about the pandemic, epidemic disease, armed conflict, like what is going on in Iran and other places, natural disasters, and mass displacement. When these happen, they, yes, disrupt a health system, but quite apart from that, they place extraordinary pressure on constitutional governance, human rights protection, and international legal cooperation. And for that matter, health and humanitarian emergencies must be understood as intensified sites of legal responsibility and not just a temporary interruptions of legal order. That is to say that when these emergencies occur, they present an extraordinary challenge to how law should deal with situations or problems. Of course, we cannot just throw our hands up in the air and say that, well, because of these disasters, nothing should be done. There's lawlessness. No. So it's not just interruption of legal order, but the fact that it brings more, greater challenge to how law deals with the issues. Now, but there's a misleading or view or misconception with respect to emergency governance, and that conception is that when these crises happen, like they should justify suspension of legal standards. In other words, there's that thinking that once you have these emergencies, then it is a sort of like a blank check, so to speak, for you to ignore all legal norms, legal obligations, and do whatever you want, because in the name of we have crisis on hand, so no law. Well, international law and constitutional law reject this assumption. And in fact, where we have emergencies, there will be limitations on rights and liberties. But the limitations should not be sweeping. They should be in narrowly defined circumstances. With respect to derogations. If there will be derogations at all, that is, derogation means that you completely you are reneging on certain legal obligation, which is supposed to inure to other people's advantage, like upholding their right and so on. So if there's going to be derogation at all, it has to also be very restricted, so that you don't have a situation of a legal vacuum. So that is a point that we have to keep in mind. And if we have emergencies, like any of the emergencies that were mentioned, be it a natural disaster, armed conflict, epidemics, and so on, uh, it brings to the fore the relevance of law as it throws up difficult questions. And what are these questions? First, who decides which rights may be limited? Who makes the decision? Is it the politician or the court? Or who? Who decide which rights are to be limited? And then, what evidence is the decision going to be based upon? Say that due to XYZ, it is legitimate for some restrictions to be put on certain right. And again, if there's going to be restriction or limitations of right at all in the face of the crisis, what should be the duration? How long are the restrictions going to remain? What safeguards are there to ensure that we do not have unjustified violations, as it were? And more importantly, how should scarce health resources be allocated? And that is what is of interest to us in this model. Healthcare and human rights. And we are looking at the health and emergencies, humanitarian emergencies. Yes, if you have humanitarian emergencies, one practical problem is that we have severe shortage of health resources, health personnel, and we have a large number of people who certainly need support health-wise, but what we have is not enough. So there's also the challenge of sacrificing equality, dignity, and accountability in health care. So these are some of the challenges. So in this lecture, we proceed from the premise that health protection and human rights are not competing values. So it's not like we don't have competition between health protection and human rights, particularly in emergency. But more importantly, they reinforce each other. So therefore, under international human rights law, we have the right to health. But the right to health under international human rights law does not become irrelevant when we have emergencies, be it natural disaster, be it pandemic or any of the epidemics, as it were. Rather, the right to health acquires even a greater normative force when you have such emergencies. In the same vein, when it comes to other legal regimes like international humanitarian law, refugee law, and constitutional emergency provision like what we have in Article 32 of the 1992 Constitution, they introduce additional layers of protection and constraint so that ultimately the right to health is safeguarded. And for that matter, the rare challenge which legal systems or which countries face in trying to navigate the puzzle which humanitarian emergencies present vis-a-vis healthcare and so on is how to choose between these regimes, that is international human rights law, international humanitarian law, refugee law, and so on. And two, uh, coordinate coherently, not like to pitch one against the other, no, but how to integrate them so that despite the fact that we have problems of urgency, yes, certainly when we have these emergencies, we have urgencies. There's a desperate need for health interventions and so on. At the same time, we also have the difficulty of scarcity, as it were. So the rare challenge for legal systems, the rare challenge for various countries is how to bring international human rights. Of course, those who are lawyers will appreciate that the international human rights law, will be told, is the legal regime which governs human rights during peacetime. And the international humanitarian law and the refugee law, as it were, is supposed to be the legal regime which governs human rights during war or some other non-peacetime, so to speak. I've seen that somebody hand is up 1GS. Yes, let's hear him. Is it a mistake? So as I indicated in the beginning, in this discussion, we are going to use what we call the concept of a legal trudge. And trudge is a concept borrowed from clinical medicine. And what it seeks to do, what a legal trudge seeks to do, is to provide explanation as to how our legal system actually create a priority where we have a situation where we have a large number of people that are in need for urgent health intervention, but the resources are stretched. You don't have enough. So how do you prioritize who to give some health intervention to and who to delay? So, and how do you justify that in emergencies without being accused of you abandoning legality or doing something unlawful? And as I said, those of you in the clinical medical practice, you understand this concept of a trudge very well. How you used to create various ranking or prioritization within your practice in the face of obvious shortage or insufficiency. Yes, who is JS? Jacqueline, okay.
I would like to know, please, in case of pandemic, like as we experience in COVID-19.
Maybe if you don't mind, I would say that hold on to your question and let me teach for significant part so that if your questions are not answered, then you can still come in. I want to finish this topic today. Okay. So put your question now. I'll come back to you.
All right. Thank you, sir.
All right, good. So as I said, this idea of legal trudge is just an analogy we are trying to adapt from what actually happens in day-to-day clinical practice, especially. Let's say that those who are what they call the casualty. There's a major accident. You have maybe about 100 patients you have been brought there, and the facilities and the things that you have can probably take care of just about 30. Now, how are you going to determine which of the 100 should be given attention first? I think that those on the ground, they have a way of doing that. And that is the trage thing. And that is what we are also adapting for our discussion as it were. Good. So our friend Jacqueline wanted to ask a question about COVID-19, and I indicated from the outset that we will use, how Ghana responded to COVID-19 as a case study for some of the things that we are going to be discussing in this.
During the COVID-19, we realized that every evening, the government of Ghana, the president to be precise, that time, incidents and the lockdown issue and all that incident.
Are you saying that is it the duty of the president to be doing the brokings? Is that the question?
Yeah, is it the duty of the president to be involved in pandemics or the minister of health as at that time?
Oh, okay. I mean, the COVID-19 was seen as a humanitarian thing, and certainly the president has would like to show leadership, and not necessarily the case that the president should be the one broadcasting to the country about what is being done, what is not being done. A minister could have done that, but if the president did that too, it's also within his right and power. After all ministers are appointed by the president, whatever any minister can do, the president who is appointing them can take over and perform that ministerial function. Yeah, so that is, but there's nothing, legal imperative that he must necessarily do that, or it is wrong for him to also do that. Yeah. Right, Jacqueline?
The network took me off.
Jacqueline, let's have the class when we finish, okay? All right, good. Maybe you can write you can write it, and then those who heard my response can also put in the chat, so that because the network is not helping you. So put it in the chat, and then those who heard what I said, please, somebody should capture my response in the chat for attention of Jacqueline. Thank you.
Thank you very much.
Very well. Good. So let's look at these issues. Are health and humanitarian emergencies exceptional events, or are they now a permanent feature of modern governance? In other words, the issues of pandemic like COVID-19, malaria outbreak, all the disasters, just like the gas explosion at that village, and all the humanitarian no problem associated with it. Are we to treat them as exceptional events, or will you say that if we look at how things are, they should be seen as having, become a permanent, or a constant feature of modern governance? So that is the question. Yes, what are your thoughts? Should we accept that now these are not just something which happen one-off, but now it's become part of us, and with that matter, our governance system should have a permanent place for it? That is the question.
Hello, my lord.
Yes. Yes, proceed.
My lord, it's true. We have to consider it as our everyday life. A hospital setting. We have a program we do that mass casualty preparedness. So every contact you have to prepare. If there's an accident somewhere, a bad accident, and a number of people are involved, how do you handle those situations? So you are prepared, even though it's not an actual situation. So as a nation, we need to prepare ourselves for these things, that these things are part of our life. It can happen. It may be flooding. It may be the gas explosion. It may be even the plane crash. This plane can crash in a major city. How are we prepared to handle these things? We should begin to see as part of us, so that we can develop a national plan, emergency preparedness towards them. If not, I mean, it can even be earthquake, and all these are things that as we exist, it will happen. So like in the hospital setting, that we get prepared for mass casualty situations. The same thing, we just have to have a national emergency preparedness, regime, so that we will know which team, what are the agencies to involve immediately we have such a situation. What are the emergency things to activate? We need to consider it as part of our everyday plans. You can even see that even the cardiac, somebody gets collapsed. Are you able to perform the basic thing that will revive that person? These are elsewhere. Everybody is trained. But in our part of the world, a lot of people don't have any basic knowledge on this EPR thing. So we need to consider them as our daily life, and then prepare for them. Thank you.
Right, thank you, Doc. All right, so in view of the response that you have given, what are the implications for how law should regulate emergency power? Now, from your response, you seem to agree that health and humanitarian emergencies, despite the fact that the emergencies so-called, are realities which we have to accept that they can happen, they will happen. We don't know when, we don't know how, and we don't know where, but we cannot live in a denial. Good. If that is the case, Certainly, when those things occur, they present their own challenges, and the law must come in. You may need a very strict response, and the strict response you need are such that it may not be practical for people's rights and freedoms, business as usual, to be upheld, and something more, restrictive may have to be done. So, if it is true that these health and humanitarian emergencies are not exceptional events, but they are a permanent feature of our modern governance, how should we create the necessary regulatory powers so as to also guard against giving too much powers to the government to the detriment of the citizenry? What do you think?
My Lord, if I may.
Yes.
Yes. So, my Lord, I think that laws are being enacted, or laws are being fashioned to what pertains on a normal day. But we also need to envision these emergencies or humanitarian crises which may occur, which means that it's imperative that we are able to fashion the laws such that there are graduations. What I mean by graduations here is, in the case of COVID-19, there were sweeping measures on lockdowns and all that. Our laws, there should be some form of a playbook, so to speak, where you have 16 regions based on certain prevailing situations. Let's assume the situation starts in Accra and Kumasi. What are those measures that needs to be put in place, proportional to the situation on ground? So as much as possible, the law should take cognizance of proportionality of the response on ground, and also recognize the fact that if, for instance, the laws are taken into cognizance proportionality, there are also certain potential human rights breaches that may arise as a result of the interference of the state. So if we are able to set clear parameters, assuming in Accra, we have, say, half of Accra being plagued by COVID, what is that proportional response, and what is the reach of the stakeholders? So if there's that clarity, we are able to easily tell when the stakeholders are enforcing a proportional response or a disproportionate response. I'll probably maybe use the ongoing situation in Minnesota as an example, even though that necessarily be directly in quotes a humanitarian crisis, but the ongoing issue with ICE, for instance, where now the president wants to invoke the Insurrection Act. This was something that obviously stakeholders on the grounds are making a case that there are other ways to go around it instead of the president invoking the threatening the Insurrection Act. So I think that first we need to be able to grade the response of the humanitarian crisis, and for each response there should be a certain response that would be commensurate with whatever is happening in reality, and that would at least give people the confidence that whatever decisions stakeholders are taking in response, at least a justifiable cause, or there's a justifiable rationale being taken. So in some, there has to be proportionality, but it should be documented so that if an instance of COVID-19 should occur again, we would have been able to have learned from the current situation. Because, for instance, when the 1918 flu happened, the Spanish flu happened, and we had offshoots of that coming through Takrady and other oceanic areas in the Gold Coast, so to speak. A lot of the regions, even though they were not as enlightened as we are now, they did not invoke a total lockdown. There was mobility all over the place, and they were able to still contain it. So in 2019, 2021, with advanced technology, we imposed on our. Of course, that should tell us that it was not sincerely driven by data. If there was a playbook which was guided by gradation and proportionality, I'm sure that people may not have necessarily regards to certain acts that we're thinking. Thank you, my lord.
Thank you. We will come back to this. But let me ask this particular question. What distinguishes a health emergency from humanitarian emergency in legal terms? Any thoughts?
I think situation is orchestrated by a disease people so much, whilst humanitarian emergency could be a natural disaster, even though also has a health aspect. For example, like the mediation that happened in the US, it is humanitarian situation and it has a health aspect to be affected the sources of water, which eventually will contribute to people's health negatively. So humanitarian is either natural disasters, wars, or any other situation apart from it being originated by a health condition, like a disease outbreak or any other health events.
Thank you. So we need to appreciate that health emergencies, humanitarian emergencies are a multi-dimensional legal crisis. That is to say that when they occur, they have various dimensions. They affect us in various ways. They will impact multiple systems like health, to affect the health, governance, economy, and law, as it were. They are all placed under severe strain. If for nothing at all, remember the pandemic, COVID-19, how our economy was affected. People were not working. At some point, there was even the need for the government to be giving some payout or some living support to some citizens because of the lockdown. Again, if you have a Ebola outbreak, the same thing. Or if you get the climate-related disaster like flooding, it will destroy farms, various economic activities. If you have armed conflicts, certainly there'll be mass displacement. People will have to flee from violence. You cannot go about work. Economy is affected. So many other things are affected. Now, from the point of view of law, where you have emergencies like that, they test four-dimensional aspects of public law. So first, the binding force of international human rights law with respect to, let's say, Article 12 of the International Convention, International Covenant on the Communication and Cultural Rights, particularly the right to health, is tested. Then two, the operability of international humanitarian law, IHL, in protecting civilians, particularly if you have like armed conflicts, medical personnel and health infrastructure. These are all affected during armed conflict. How to protect civilians, how to protect medical personnel, how to protect hospitals, so that if, for example, even combatants are even sneak into hospitals, despite the fact that they are combatants under Geneva Conventions, the rules of engagement with respect to theater of war, you are not supposed to, for example, extend your violence there. And thirdly, the effectiveness of refugee protection regime, particularly prohibition of refoulement or remorfoir. That is to say that when refugees coming to your country, they're escaping a danger, you don't have to return them to the source of danger where they are coming from. You don't say that's for my country, I don't take refugees. When they are really running from danger, then you send them back. And fourthly, the legitimacy and limits of emergency powers exercised by states under constitutional international law. How far should government be allowed to go in placing limitations on rights and freedoms of citizens during emergency? If you look at our constitution in Ghana, for example, particularly if you look at Article 31 to 32, you notice that we have an elaborate regime which govern emergency powers. So when you go back, we just look at Article 31 and Article 32 of the Constitution and see how the framers of Constitution have actually calibrated the kind of emergency powers the government can exercise so as not to completely undermine fundamental human rights and freedoms enshrined in the Constitution. So therefore, when we have emergencies, the main concern is not just to suspend everything, but how to properly regulate how rights are restricted or are contained. How do you contain executive power, check executive power against arbitrariness? Just like the COVID-19 Position of Restriction, Imposition of Restriction Act, the president could, by executive instruments, delimit certain areas and say that all those in this particular area, you are not allowed to move beyond it because we are trying to check the spread of the pandemic. That may well be true, but it's also susceptible to abuse. And again, how to contain avoidable suffering. Certain suffering can be avoided or reduced even during emergencies. And at the same time, how do you permit effective and timely action in public interest when you have emergencies? It is a desperate situation. And as we say in everyday parlance, desperate situation call for desperate response or desperate actions, isn't it? Good. Yeah, so if you have these emergencies, we also need swift action in the public interest. So, in terms of the conceptual architecture of health and humanitarian emergencies, we need to note that humanitarian emergencies are best understood as processes. Processes in the sense that they are not just an event, we just, if you like, just okay, or moments. And if you look at the literature, they all recommend or they all concede that respect to protection of health in the face of humanitarian emergencies, there's a need for being mindful of what they call the structural sequence. Things happen in a certain order, and that should be appreciated. So first, we have the trigger phase. The trigger phase, that is the precipitating event, the event which actually bring about what you call like the emergency. So we can have an outbreak of infectious disease, maybe like coronavirus, Ebola, cholera, or you can have armed conflict or unrest, civil unrest, like what is going on in Iran. You can have a natural disaster, like a flood or drought. You can have a mass displacement. What Israel is doing in Gaza, moving people from the original homes and so on. So we have the trigger phase. And when the trigger phase, that is the event which sets or which signal that yes, we have a humanitarian emergency. You move from the trigger phase to what we could call the systemic overload. So once these things have occurred, either outbreak of infectious disease, mass displacement, or whatever, you are going to have a rapid or cumulative strain, either very fast one or incrementally, but in a sustained manner. You are going to get like a strain that is an overstretch on health systems, surveillance capacity. The health system are overworked so much so that it's unable to take up the patient burden or whatever, or even surveillance capacity, the ability to monitor and check any escalation. All those things are overstretched. You also have a rapid or cumulative strain on water, sanitation, and hygiene. Wash. Water may be polluted or demonstrated of it. Sanitation may even worsen. And that may also trigger another form of emergency. Let's suppose that you are dealing with the flooding and you have a choke, gutters and so on. You could get a cholera outbreak. You can also get the escalation of malaria. Also be strain on food supply chains, certainly. And that is why we're saying that they are multidimensional when you have these problems. And also rapid or cumulative strain on governance, security and administrative authority, obviously. We also have predictable human impacts. Once we have the thing have been triggered by any of the precipitating events, the systemic overload, your systems, health, whatever, they're overstretched. Certainly, you're going to have a disproportionate morbidity and mortality among certain vulnerable population. Children, they may be hit more because of their extreme vulnerability. So you may probably get more death or something like that. Refugees and internally displaced persons, women, especially pregnant and lactating mothers, and in persons with disabilities, chronic illness or poverty. So just imagine you have people who are diabetic, right? Or who have pressure and other things. And you get any of these problems that we are talking about. You are going to certainly aggravate their situation. They may not even get their regular medicine and so on. So that is some of the problems. And if you look at the literature, those who have done studies on some of these public and health humanitarian emergencies, the evidence from the literature indicate that mortality rates in complex humanitarian emergency may rise more than tenfold above baseline levels. So if in a normal life situation, maybe you have 100 people dying from, let's suppose, malaria or cholera, or even just die generally. If you have a complex humanitarian emergency, that can rise by tenfold. So let's say that times 10, as it were. So instead of 100, we're going to have 1,000. Now, when you have this predictable human impact, another thing is that there's a externalization of response. You may need support from outside. So there'll be activation of humanitarian actors. International organizations like the World Health Organization, UN High Commission on Refugees, and so on. You can have the triggering of emergency legal regimes. Either you want to derogate from obligation to oppose certain human rights and freedoms, or maybe you want to impose restriction, like what the government of Ghana sought to do. In 2021, following the coronavirus pandemic. So the problem or the process, the humanitarian emergency, will trigger or activate overlapping regimes simultaneously. So international human rights law become relevant, international humanitarian law become relevant, refugee law, and also domestic constitutional emergency law. So they are all playing some role to provide a meaningful response to the complexity, occasioned by that humanitarian emergency. And what is important is not preferring one over the other. Don't say that because of this emergency, let's forget about all human rights. Let's pay attention to international humanitarian law. But just let's look at if there's something is in refugee law which is relevant. Let's be facilitated with that and forget about all other legal norms or regimes. No, that is not it. You need to coordinate them coherently. And we've already talked about vulnerable groups, which are hit hard during humanitarian emergency. And again, this vulnerability during emergencies is predictable. The obvious reason being that we have structural inequality. If you take children, for example, they experience higher mortality, malnutrition, in some cases, what we call koshoko, interruption of vaccination, and long-term developmental harm. There are certain vaccination doctors and public health practitioners will tell us are supposed to be taken at certain stages. So assuming you have a humanitarian emergency, and if it lingers on for a longer period of time, it's certainly going to affect the right timing of such vaccination. And you will predispose children who have missed those critical vaccination to whatever they're supposed to have been protected against. Jacqueline, your hand is still up. Is it up or just by accident?
No, it's down. It's down.
All right. Yeah, so if you look at the Convention on the Rights of the Child, particularly in terms of Articles 6 and 24, states have a heightened or an increased obligation, non-derogable duties. That is, they are not supposed to renege on the obligation regarding ensuring survival and access to health services for children, even during emergencies. So those obligations are supposed to be kept by states towards children, even during emergencies. And I've explained to you the necessity for that. For example, when it comes to vaccination, some vaccination may be, for example, time sensitive. There's a particular stage in the development of a person he or she must get. And if you don't get it, then you are going to be in trouble, as it were. So that is why there's a good sense in the position of the Convention on the Rights of the Children that some of these rights are actually not derogable. Again, another vulnerable group, refugees and displaced persons. In Ghana, we have, there was a point in time we had Bujumbura, beyond the Kaswa, refugees from, I think, Liberia or so. They were kept there. And refugee camps become sites of prolonged emergency. The Bujumbura camp, for example, they were there for a long time. They were there for a long time before there was a program after peace has finally returned to Liberia for them to be encouraged to return. So under the Refugee Convention, particularly in terms of Article 23 and 33, states have obligation to ensure access to public relief, equality in rationing, and also non-refoulement. Non-refoulement means that you are not supposed to just return, you are not just supposed to return refugees to the very danger they are running away from, or to third countries which are not prepared to accept them. And if you have a health emergencies and you create situation which make individuals return to a place where, because of epidemic or whatever reason, the health system have collapsed, it will be treated as indirect refoulement. What do you mean? Refoulement is a French word, although it's written reformant, but refoulement, that's how they pronounce it. Is where you are sending a refugee, somebody who is trying to escape from danger and try to life and get a safe place. You are sending the person back to the very danger he or she is running away from. So that is a refoulement. But we are saying that in a situation where, for example, individual has escaped from a certain danger and or he's pushed back to a place where the health systems are for collapse, either because of war or some epidemic. Despite the fact that we don't have armed conflict there, to the extent that the individual is returning to epidemic ravage or collapsed health system, that will be an indirect reform, because the person is going to die or is going to get his health exacerbated or aggravated, as it were. And that becomes a matter which affects not only refugee law, but also the right to life and Article 6 of the International Covenant on Political Rights. But the point to note is that in emergency, the right to health, as protected by Article 12 of the International Covenant on Economic, Social, and Cultural Rights, is not suspended. It continues. So states are obligated to take necessary steps for the prevention, treatment, and control of epidemic, endemic, and other diseases. And this obligation subsists. It does not recede in emergencies. It even intensifies. And that is why the UN Committee on Economic, Social, and Cultural Rights, in their general comment number 14, will affirm that states retain core minimum obligation, including non-discriminatory access to essential health services, provision of essential medicine, equitable distribution of health resources, minimum public health infrastructure. All these are part of the minimum core obligations expected of states. Now, there was a cholera pandemic in Rwanda. So the international organization, Medicine Sans Frontiers, they did a study to try and understand how the obligation of states with respect to the right to health was implicated during the cholera pandemic in Rwanda. And they noted that the epidemic was not sudden, but it was something which they could have foreseen. The cholera is, of course, when we are all rational beings, we can appreciate that cholera epidemic is not out of the blue. It is complete or a failure to invest in sanitation, water, and have governance and which ensure that people are doing the right thing. If you ignore that over a period of time, there will be implosion. And then when it has reached the dangerous proportion, it will hit you as a cholera. And legitimately, so that is why Medicine Sans Frontiers, in their study of the cholera epidemic in Rwanda, rightly noted that the epidemic was not sudden. It was foreseeable consequence of chronic underinvestment in water and sanitation and weak preventive or governance. So therefore, where you have a structural neglect in the sense that you don't, for example, put resources in sanitation, you don't ensure that you have proper toilet facilities, proper sanitation system, and you just leave things like that. Ordinarily, you reach a point where it will give rise to a problem, maybe cholera or typhoid, dysentery, and so on. And that would definitely violate the right to health. So please, I've asked you to look at the principles and guidelines on human rights and public health emergencies published in 2023. And that guidelines would emphasize that prevention and preparedness are themselves binding human rights obligation. So that is very important. You have to, if you're talking about, if you want to, deal with humanitarian emergencies, health and we cannot take for granted preparedness. And as one of you rightly said, that these things, there are a lot of things that they are unfortunate, but being human beings, they are part of us. Whether you find it palatable or not, they will happen, but we don't know when, we don't know where, we don't know how. So we have to hold ourselves in what? In preparedness. And the same thing applies to humanitarian emergencies. So I ask you, can failure to invest in health infrastructure before an emergency amount to a violation of the right to health during the emergency? What do you think? If the state has not invested in health infrastructure during normal times, and later we have an emergency, and as a result of the failure to invest in the health infrastructure, the emergency becomes a huge catastrophe, which would not have been so if there had been investments earlier on by the state in health infrastructure. Will you consider that as giving rise to violation the right to health? Yes, what do you think? Yeah, Regina. Rebecca, yeah.
I was just about asking the question before you scrolled up, and I saw the question under the lecture notes. So yes, it can be considered as violation because of the state's obligations under the international human rights law you explained earlier. That all states are accountable; they are responsible to ensure that we don't run into emergencies. We are responsible to invest in health infrastructure and then preventive measures. So if you fail to do that as a state and we run into emergencies, it can be considered as a violation of the right to health for humans. But I also wanted to ask a question earlier on. But please, can I go ahead?
Yes.
Yes, about the refugees moving back to previous countries where they sought to be running away from. At what point will you confirm that their previous home countries are safe for them? International, let me say, supervisory bodies have confirmed that they have rebuilt state infrastructure with regards to housing, health, sanitation, everything for up to standard. And then can an individual opt not to go back because of psychological trauma, even when they have been prepared to return back to their home country? Can someone say that they don't want to go back?
Okay. Well, actually, if you look at things, no human being who has a reasonable assurance that normalcy has returned to his home country will say he will not go. It's possible, but it's quite rare. And we don't, under refugee law, we don't force a citizen refugees to return unless we've exhausted all verification. Yeah, so that is how it is. But as I said, in reality, nobody wants to be a stranger in another person's country without his choosing. So if he or she is pushed by danger, which existed in his country at some point, and if it's absolutely clear that the danger is gone and everything is normal, everybody would like to go back. You take the Liberians, for example. Unless somebody just chose to live his life in Ghana, otherwise, everybody would like to go back.
Okay. Thank you.
Hello, my lord.
Yes. Yes.
Difficulty with respect to as to whether or not the failure of the government to invest in health infrastructure violation of the right to health. I don't know. I know some years back we used to have this African peer review mechanisms.
Yes.
The country peer reviews themselves and see the preparedness towards infrastructure and all these areas. But to say it's a violation of the right to health per se, I find it very difficult. Even if you are coming under Article 10, which says if you are alleging that any provision of this constitution with respect to the fundamental human rights and freedom has been or is likely to be contravened. So I don't know, to say that lack of investment in infrastructure is likely to contravene somebody's right to health. I find that very difficult, but I just wish that I get some clarity on it, whether the lack of investment in the health infrastructure could amount to a violation of the right to health per se, or it's a likelihood of that right being violated.
All right, Charles, good. When it comes to international human rights, apart from individuals enforcing rights, which implicate directly on their interests as individuals, we also have what they call the reporting, obligations of states. So states are supposed to report to bodies established under this instrument periodically regarding steps they have taken to live up to the obligation imposed of them by the relevant instrument. So in talking about the fact that where it can be demonstrated that neglect or lack of investment by the state over a period of time, for example, has undermined the right to health, where your report goes before the monitoring bodies, it will be a subject matter of adverse commentary that you haven't done enough. If you look at your budget and if you take an account of maybe how much you have been earmarking for health. So that is the kind of the angle we are coming from, but not just an individual just going to court and make such a case.
My lord, if I may.
Yes.
Yes. So, my lord, I recall that at the AU level, they sought to make some level of commitment to were in the fray for that particular declaration, committing at least 15% budgets to the health sector. So, and year on year, if a country like Ghana is unable to meet such obligation under that declaration, would there be a justifiable course to take up the state on such situation when there's an emergency and the state feels in its obligation to make an allocation as a result of that situation? Thank you.
Right. As we mentioned, it was a declaration. So declarations are usually, they are not juridical norm creation instruments. They are not treaties. They are not convention. And for that matter, they don't carry enforceable obligation, except that if you're doing international law, there's something called like the state practice and then the opinion juris, that's what international law. So if we, for example, observe that despite the fact that you were a party to this declaration, consistently you are living, not in accordance with what you undertook to do, that could be a subject matter of adverse commentary. Yes, but of course, when it comes to international law, one thing we should appreciate is that much as it said that some will even say that international law, is not law in the sense that you don't have like a serious enforcement mechanism. It's still law because states would like to justify their actions or inactions by reference to international law. And that is why, quite often when things occur, states would like to justify what they've done, saying that what they've done is consistent with international law, what somebody has done is in violation of international law. So that is how it is. Sometimes it's not just only something being enforceable through a judicial or quasi-judicial forum, but adverse political commentary could also be a way of ensuring that people will take their obligations and commitments serious. Okay, so I think we've very well. So we've somehow talked about where should the line be drawn between policy failure and legal breach. Now, should prevention and preparedness, and we've only talked about this, whether prevention and preparedness should be treated as enforceable legal obligation rather than aspirational policy goals. So that if you look at the state, and the state does not appear to have in place systems and mechanisms, who suggest that should any health emergency occur, it has the response system to be able to deal with it. Can we take that up legally against the state, or we should rather see those matters as non-justiciable? They are just aspirational policy goals. So therefore, as Charles was bringing up, can you go to court and seek, for example, judicial review, maybe such as mandamus, to compel the state to put in place certain arrangements, mechanisms, surveillance, to be in a state of preparedness to contain or respond to any health and humanitarian emergency that may arise? What do you think? So let me give you another example. If you have like a massive fire outbreak, that is also, a disaster which will implicate health. So can you say that the fire service is not a resource? So if you have a fire outbreak at the airport or anywhere, it's going to be a big disaster. So you want the court to compel the state to vote more resources towards, let's say, the fire service. Should that be legally enforceable, or should it just be non-justiciable, just aspirational policy goal? What do you think? Anyway, think about it.
So, I think that is where policy meets legal requirements. So you wouldn't want to say that it should be a legal obligation just so that it become like a truth hijack for the government, but it should also be a positive aspirational goals, so that both policy and legality serves as checks and balance on each other. So there must be clear indicators to ensure that emergency preparedness is on point. Emergency units that require to be much resourced are properly resourced. So that in the event of emergency, so that there is definitely going to be policies versus legalities, not necessarily being a complete or only legal obligations on the state.
All right, thank you. Now, finally, is it coherent to hold states legally responsible for foreseeable epidemics such as cholera, but not for novel pandemics? In other words, where a particular pandemic, like maybe like cholera, as I indicated, and as the medicines, Sans Frontières, their study in Rwanda indicate and concluded that if you look at the cholera epidemic over there, it was something which was not out of the blue. It was something foreseeable. Now, so let's keep that in mind. So where it is foreseeable, will you say that we should be able to hold the state legally accountable for that, as opposed to something like coronavirus, which was novel in the sense that it's happening for the first time and nobody could have anticipated it, just happened, boom. Should we say that for novel pandemics, the state should not be held responsible, but for foreseeable maybe epidemics or humanitarian situation, which were foreseeable, meaning that there were warning signs and it could have been anticipated that if XYZ was not done, it will occur. And they were not done and they've occurred. Should we hold the state responsible? What do you think? Yes, Rebecca.
My Lord.
Yes,
Charles. Under these circumstances, I hold the view that the state should be held accountable. Just the perennial Accra cholera incident. Currently, sections of Accra are struggling with water crisis. And then the state knows that it is its responsibility to provide them with such potable water. So in a situation where the people suffer these infections, I think they are right to have it guaranteed, and they can sue the state in respect of that. So these are foreseeable. So we can hide under the law of thought to say that the state actually, reasonably can foresee that this can happen. But in a situation like the Ebola, like the COVID-19, things that, or the PRT disaster and those kind of things, it will be very difficult, but those are accidents, properly so called. As I find it very difficult that one will go to court for enforcement. But this foreseeable incident, the law should be on their side. Thank you, sir.
Right, thank you. Rebecca, your hand up, and then Mavis.
So yeah. I think I side with Charles in that regard. That earlier, the Rwanda cholera case.
Yes.
They mentioned that the state must be responsible or intentional about investing in sanitation because of the foreseeable epidemics. So anything that has to do with cholera the state must be held accountable in any way. If we have to ensure that our sanitation laws are working properly, the state has to ensure that. If we have to revisit the old era where we have these town council people moving around, making sure that people are doing, the state must be very responsible and intentional about everything that has to, so that we can prevent the foreseeable epidemics such as cholera. But for the novel one, as the even that one, that is where we also have to put in some or emergency preparedness. That one we cannot hold the state accountable for that too much. The state must be intentional. Thank you.
Right, thank you. Mavis.
Yeah, thank you very much. Yes, I also hold the same view as has been shared. So, and because the state is aware, they should prepare for such occurrences. And even in the novel cases, the state should ensure that we have robust health systems and other systems in place to respond to such unexpected pandemics. Thank you.
Right, thank you. Sylvanus?
There was a question I want to ask earlier concerning international law on high refugees. Where a state renege on fulfilling law to accept refugees from another country, how does the law reprimand that state, or how is that law enforced? Is it binding, or it is just based on the benevolence of the state that is supposed to accept the refugees? In reference is the Liberian Civil War, where Cote d'Ivoire refused to take in refugees, even though they were closer to but Ghana, on the other hand, received them. In such situation, which international body is responsible for enforcing that law?
Right, so first of all, what you should remember is that every country, your citizens are potentially future refugees. That is the starting point. But we don't have mandatory obligation to accept refugees. But where you have accepted them, they are not supposed to do reform. In other words, when you accept them, you cannot send them back. So earlier when somebody asked a question, can you force them to go back? So if you look at the convention, that's the 1951 convention relating to status of refugees, for example, we will be told, among other things, that no contracting state shall expel or return, that is refuge, a refugee in any manner whatsoever to the frontiers of territory where his life or freedom will be threatened. So once you have allowed the refugees to come in, you cannot send them back. But as to whether you have obligation to accept them, you cannot be forced to take refugee. But we have like the UN High Commission on Refugees, and where you have put up a behavior which, for example, undermine your obligations and best practices with respect to what we are supposed to do towards refugees, then they can issue the necessary statement on you. Okay, so we should be drawing the curtain down tonight. Okay, Adeline, sound is up. Adeline, let's hear you before I'll sign out. It's probably a mistake. Okay, no problem. Then have a good night.